This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today it's time to speak about the fact that insurance fraud is a violent crime, and bad men must serve the time for crimes they commit, from insurance fraud to murder, including carjacking with a weapon. After a multiple-count indictment against dozens of members of the Gangster Disciples, 5 of them, Alonzo Walton, Kevin Clayton, Donald Glass, Antarious Caldwell, and Vancito Gumbs, appealed their convictions and sentences following a joint trial. Each raised several grounds for reversing, contending they were overcharged and oversentenced. Some argued that the Racketeer Influenced and Corrupt Organization Act, RICO, violated the Sixth Amendment because the jury failed to find that the conspiracy involved murder. In the United States of America versus Antarious Caldwell et al., the United States Court of Appeals for the 11th Circuit on August 16, 2023, affirmed all but one sentence and all convictions. The Gangster Disciples began as a loosely affiliated network of street gangs in Chicago, but later became a hierarchical national criminal organization. Its hierarchy consisted of a chairman and national board for the country, governors of governors in charge of multi-state regions, governors in charge of each state, regions in charge of counties, and coordinators in charge of municipal-level divisions, or in larger cities, subdivisions called counts or decks. The chief enforcer managed a team of enforcers who exacted punishments for violation of the gang's rules, such as the prohibition against cooperating with the police. The indictment charged an array of criminal activities, including carjacking and insurance fraud, attempted robbery of Eric Wilder, murder of DeMarco Franklin, Stone Mountain Inn and Central Avenue shootings, murder of Robert Dixon. The last crime relevant to the appeal was Glass's killing of Robert Rampage Dixon in August of 2015. The principal charge against the defendants was Count 1, which charged that the defendants conspired to conduct and participate directly and indirectly in the conduct of the Gangster Disciples through a pattern of racketeering activity in violation of the RICO Act. The indictment named 34 defendants, and this appeal concerned the joint trial of Walton, Clayton, Glass, Caldwell, and Gumbs, who were convicted, and Perry Green, who was acquitted. The district court ordered that all the defendants be secured with ankle restraints throughout the trial. Walton was convicted of racketeering, conspiracy, carjacking, and using a firearm during the carjacking. Clayton was convicted of the racketeering conspiracy. Glass was convicted of the racketeering conspiracy, acquitted of the murder of Robert Dixon, convicted of carrying a firearm during a crime of violence, namely the killing of Robert Dixon, convicted of causing the death of Robert Dixon with a firearm, and acquitted of 2 marijuana possession charges. These were not nice men. Caldwell was convicted of the racketeering conspiracy, the attempted Hobbs Act, robbery of Eric Wilder, and carrying a firearm during a crime of violence. The attempted robbery, Vancito Gumbs was convicted of the racketeering conspiracy. For each of the convicted defendants, the jury found that the RICO conspiracy involved murder. The jury acquitted a 6th co-defendant, Perry Green. The 11th Circuit concluded that the district court did not abuse its discretion in its pretrial and trial procedural decisions, and that the district court also did not abuse its discretion when it declined to ask questions during voir dire about unconscious bias, although not in effect when the trial occurred in 2019. The revised rules require that notice of expert opinion testimony comes sufficiently before trial for adequate preparation and does not measure timeliness based on the expected date of the testimony. The court also found that the ankle restraints did not violate the defendant's rights because the common law rule against shackling prevents creating an unfair impression of guilt for the jury and is limited to contexts that implicate the danger. However, the record made clear that the ankle restraints were not perceptible to the jury, and no defendant alleges that he lacked access to counsel. The district court ordered that the restraints be placed on the defendant's legs only, that they be muffled to prevent clanking, that a curtain around the defense table conceal them from the jury, and that the defendants enter and exit the courtroom outside the presence of the jury. The district court also did not impermissibly depart from its neutrality when it questioned a witness. A trial judge is more than a referee to an adversarial proceeding. Consistent with the common law tradition, the judge may comment on the evidence and question witnesses and elicit facts not yet adduced or clarify those previously presented. The questioning is limited only by the principle that a judge must maintain neutrality between the parties. The district judge stayed well within those bounds. He asked a single question without commenting on the veracity or relevance of the witness's testimony. The district court did not err, therefore, let alone clearly err, when it asked a witness for that information. The jury found that the conspiracy included actual, not inchoate, murder as part of the racketeering activities. He instructed the jury that acts involving murder for the purposes of finding the two racketeering activities needed for conviction extended to Georgia law conspiracy to commit murder and attempted murder, but the district court never said that the jury should read the phrase involve murder to mean involve acts involving murder. There was, the court concluded, evidence that supported the finding that Walton intended to cause death or serious bodily injury in the carjacking. Pointing a gun at someone and demanding money is the kind of evidence on which prosecutors may rely to prove the mens rea, the evil intent for carjacking. And they did. Caldwell's conviction under the Armed Career Criminal Act and his sentence, however, had to be vacated because the U.S. Supreme Court recently held that attempted Hobbs Act robbery is not a crime of violence, so the 11th Circuit was required to vacate Caldwell's conviction under the Hobbs Act and remanded for the district court to re-sentence Caldwell for his remaining counts of conviction. All the other convictions and sentences were affirmed. In my opinion, insurance fraud is a serious crime. It's a violent crime often. It is not as serious as murder. But when a group of men work together to commit murder and insurance fraud, they are acting beyond reason and deserve as serious a sentence as the court can provide in accordance with the law. The appeal was their right, and the 11th Circuit had the obligation and right to disavow them of their arguments and only changed the sentence because of a change in the law from the date of the trial to the date of the appellate decision. This video was adapted from my blog, Zalma on Insurance, and is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of the daily blog postings, usually 5, sometimes 6 a week. And you can also subscribe for free to the rumble.com videos and the YouTube videos. And if you wish further detail on insurance, insurance law, insurance coverage, and insurance bad faith and insurance fraud, please subscribe for a very small fee to my Substack publications in my local community. Thank you for your attention.